Welcome to our first online lecture for the semester. We begin with looking at things broadly. How will we learn the ins and outs of criminal law without first learning the fundamentals of what criminal law actually is? In this lecture, we're going to explore the differences between criminal and civil law. We're going to see the evolution of the American system from common law, and we're going to end with the exploration of the American court system at both the state and the federal level. So let's begin. I pose to you this question: what exactly is criminal law? From the definition on the screen, we see that criminal law is anything that makes a specific action illegal or it prohibits individuals from engaging in that behavior. From this definition, we see that there has to be a specific action and a specific code or statute that outlaws that action. This can be derived from a moral obligation, meaning it is morally and ethically wrong to steal from someone, but we're also going to have a set of codified laws that outlaw that action. Do you see anything missing from this definition? What about the punishment? What is the point of having a law in place if there's no actual consequences to violating that law? We also have to note that things change over time. Things that are legal today might not have been illegal 100 years ago, and vice versa. So what are some good examples of what I mean here? Well, think about this. Today, cocaine is a Schedule I drug that is highly regulated and illegal for use outside of a hospital setting. But 100 years ago, cocaine was used for absolutely everything. We had cocaine in our Coca-Cola, in our cough medicine, cough drops, and it was actually prescribed for toothaches. But today it's completely illegal. We're seeing the exact opposite happen right now with marijuana. What was once outlawed everywhere is beginning a trek towards legality. There is a difference between criminal and civil law. Criminal law involves cases where the state has been wronged. The state really has a vested interest in keeping individual citizens safe. That's why we have the police and correctional facilities to guard us. Even though crime might involve a specific victim, the state envisions itself as the victim. That's why all state cases involve the defendant versus the state of Texas, or the defendant versus the United States. Civil laws are a little different. Civil laws involve disputes between two people, and the state does not have a vested interest in the dispute. For example, if I run over your mailbox, you might sue me for damages. The state doesn't care that I ran over your mailbox, but you do, and you want the money back. Clearly, it's a very inexpensive example, but let's say your name is O.J. Simpson, and you were just acquitted in criminal court for the murder of your wife and her friend. But families are still looking for justice, so they choose to sue you, and now you have to pay $25 million in damages. This is an example of what happens when both avenues of the court are utilized. We now know that you can be charged in both criminal court and be sued in civil court. But the decision-making process is a bit different between the two courts. We are going to continue our efforts in looking at criminal law only this semester. In all types of criminal law, we find commonalities among them. All laws require an act to occur, or at the very least, an inaction that satisfies neglectful crimes. But we're going to pursue those actions later. The act is called the actus reus and has to be proven by the prosecution in order for legal guilt to be present. So I have to actually commit the crime in question. I also have to have meant for the crime to happen. In other words, I need intent, or the mens rea. Mens rea, or the guilty mind, has to be present, or the crime could be shown as an accident or an act of self-defense, for example. In order for the crime to not be an accident, the prosecutor has to prove that the actus reus and the mens rea occurred simultaneously, or that they have concurrence. But what if I am the one responsible for the resulting harm? For example, if I pull the trigger and you die as a result of my gunshot, then we have causation. But if I pull the trigger, shoot you, and then the ambulance runs you over when they arrive to the scene, am I still the one to blame? What actually caused your death? Causation is a sticky one, and we're going to explore that more in depth when it comes to the specific crimes later on this semester. When we discuss responsibility, this is a twofold issue. States are required to inform the general public about what is legal and what is illegal. That's why we have things like speed limit signs. The state has the responsibility to regulate our behavior, and we have the responsibility to follow their rules. If you go over the speed limit, then you are responsible for law-breaking behavior, and you will be punished accordingly. This goes for all crimes. Finally, we have defenses. Even though we might be guilty, we have the ability to defend ourselves from the charges that have been levied against us. Our best chance is to try and get the action excused, or say to the state that it was justified for a variety of reasons. We will spend more time discussing particular criminal defenses in Chapter 6. In addition to having all of the previous discussed commonalities, crimes are normally divided into different categories based on severity. To begin with, we have mala in se crimes, which are those that are illegal because they are, quote, inherently evil, and they have root in religious doctrine. For example, murder, rape, burglary, robbery, and arson are all considered mala in se crimes. Mala prohibita crimes, on the other hand, are illegal because someone has said that they are. There's no inherent evil in these crimes. They're just wrong because someone has made a codified law outlawing that behavior and making it punishable if it's committed. For example, let's go back to our cocaine example from earlier in the lecture. There is nothing inherently evil about using cocaine. Yes, I might have a high probability of becoming addicted, and maybe I commit crime as a result to fuel my addiction, but there's nothing evil about the actual drug use itself. Finally, we have a category of infamous crimes. These are a lot less common, but still pretty serious. In this category, you're going to find things like treason and sedition. As you know, we broke away from Mother England with the Revolutionary War, but we weren't ready to sever all ties to our former government. A lot of what we use today was actually carried over from the English structure. Our laws are modeled after English common law, which means that we settle disputes based on common customs and practices for the country at the time. Anymore, all of our laws have pretty much become codified, but we used to work under this structure. Common law was developed in order to bring uniformity to the people. Really, before this took place, you had all sorts of arbitrary punishments enforced for the same crime. Over here, you might get the death penalty for stealing, but over here, you might just get flogged or you might go to prison, depending on the area that you were in. There was no consistency in how things were handled. Common law took care of that problem for us. But one of the issues that we have with common law is what happens when common law does not evolve and does not allow for and continues to allow for antiquated practices. I want to bring up two issues here. First is the issue of marital rape. Marital rape laws allowed for a husband to have sex with his wife even when she did not consent. The premise was rooted in the idea that your wife is your property and it is a husband's right to have sex. Even if the wife objects, the husband is within his marital rights and can take sex by force if necessary. Marital rape exemptions were not completely outlawed in the United States until 1993. So that means that the husband could not be prosecuted because there was no law at the time that he had violated, and he did not violate common custom. In the second example, I briefly want to discuss domestic violence. We take domestic violence very seriously now, and many police departments even have mandatory arrest policies when a domestic violence incident occurs. But for a long time, it was not unlawful for a husband to beat his wife and discipline her, provided that the instrument he used was not wider than the circumference of his thumb. We call this rule the rule of thumb today. The absence of evolution did not allow for laws to develop the way that they needed to in order to account for two very unlawful behaviors that we do not condone today. Common law works only when we encounter something that we have seen before. But what happens when we haven't encountered it? What happened the very first time someone got drunk and drove and killed someone else? There was no such thing as vehicular manslaughter, so what do you do there? Or what happened the very first time someone hacked into a company's computer files or into a bank and stole their bank records? We don't have any sort of computer crime laws yet because not everyone even has access to that type of technology. Is it theft? If I stole the numbers and the code from something, was something actually physically stolen? If nothing was physically stolen, is that theft? Is it larceny? Is it embezzlement by traditional means? You then have to create new laws to coincide with the new crimes that have been committed. This means that at any time something new pops up and we don't have a law for it, we now have to figure out how to prosecute it. Normally, this results in a misdemeanor the first time it happens, and then folks are real quick about passing a statutory law that limits this behavior. I want to briefly chat about the case of Keeler versus Superior Court, which comes out of California in 1970. This case is going to exemplify what I mean by problems that occur with common law. I want to start by saying that this is not an abortion case, even though it is about the death of a fetus. The Keelers are a couple who are getting a divorce, and they have 2 children. The wife, Teresa Keeler, has a relationship with another man and gets pregnant with his child. The Keelers split custody of their teenage daughters, and one weekend, Mrs. Keeler is taking her daughters back to her ex-husband's home so he can have custody for that weekend. Mr. Keeler, the husband, confronts his wife and says that he has heard that she was pregnant, and if she was, then he wanted her to stay away from their daughters. He proceeded to drag Mrs. Keeler out of the car. He shoved his knee into her stomach. He hits her in the face repeatedly before she faints. When she comes to, she goes to the hospital, and then she has to have an emergency cesarean section. The baby's head was severely fractured from Mr. Keeler's actions and was delivered stillborn. The fetus's death was the result of the trauma applied to the mother's abdomen by the husband. There was movement from the fetus during the pregnancy, and all signs indicated that the fetus was viable in the event of preterm labor. The child would have had a 75 to 96% chance of survival, which was pretty good. Mr. Keeler was charged with the unlawful killing of a human being with malice aforethought. This means that this is premeditated murder. However, the way that the California law was written at the time stated that the law only applied to human beings, meaning that the birth had to have taken place. The question is whether or not an unborn but viable fetus is considered a human being. Common law states that the child typically needed to be born alive for that action to be considered murder. Abortion, meaning an action taken by the mother or father inflicting that action on the mother, normally would not be considered murder under this law. By 1850, the common law rule was solidified in California Penal Code, but still maintained that the fetus had to be born for murder to be prosecuted. California does not have an abortion law in place in 1850, but specifically states that the mother is the only one that can be charged for the action, meaning a voluntary abortion. This was struck down in 1969 on the basis of privacy issues, meaning that the state cannot mandate that a woman must maintain an unwanted pregnancy. In 1972, Roe v. Wade ruled that abortion laws were unconstitutional. But as we started out, this is not an abortion case. The question here is whether or not Mr. Keeler's actions should be considered murder. The court ultimately stated that no, this was not murder based on how the law was written at the time. The state legislature later changed the way that the law was written to state that murder includes the unlawful killing of a human being or a fetus. This is an excellent example of when common law fails us and we have to provide a solution for the future. Even though states and the federal government are divided for the most part, the federal government often has the last say when crimes involve constitutional issues or variations from federal law. This means that they can trump state laws and invoke the Supremacy Clause. Think for a minute about marijuana laws in this country. Many states have medical marijuana laws, but marijuana is only legalized in Colorado, Washington, and Washington, D.C. It is legal at the state level, within limits of course, but it is also illegal at the federal level. This allows for the DEA to be able to raid the dispensaries under the federal drug laws, even though it might be legal at the state level. The DEA is not after the users and their small amounts. They're after the larger amounts that are held by the dispensaries. It might sound outrageous, but the federal government can really step in at any time if they feel the need to do so. States are also subject to dual sovereignty. This means that you could be prosecuted at the state level and by the federal government for the same crime, although you would receive slightly different charges for it. Think about the Rodney King riots. The Rodney King beating resulted in the officers being charged and later acquitted at the state level. The acquittal sparked the LA or the Watts riots, but the federal government stepped in and actually charged the officers federally with civil rights violations against Mr. King. The officers were later found guilty at the federal level, even though they were acquitted by the state. even though there are two different sets of charges, this is not considered double jeopardy. Double jeopardy only applies to the same sovereign, meaning that the federal government could not prosecute you twice, and neither could the state government. However, you could be charged by both for slightly different things. For the remainder of this lecture, I would like to focus on state and federal court structures. Your book discusses the criminal justice process from arrest to the trial process, but we need to discuss the actual structure of the courts. If you look on this map, there are actually 94 district courts in the United States. There are at least one per state, and they are broken up by geographic region. I want to begin federally. Tyler is located in the Eastern District of Texas, as you can see on this map. So all new federal trials start in the district court in the Eastern Division. If you are found guilty at the district court level, you can appeal to one of the Circuit Court of Appeals. From this slide, you can see that Texas is in the 5th Circuit Court of Appeals, and that courthouse is actually located in New Orleans. If you've ever been to New Orleans, the courthouse isn't too far from the French Quarter, but if you've made it to the cathedral, then you've gone too far. It's that great big giant marble building with a ton of pillars out front. If you don't win your appeal at the Circuit Court level, then you have one more shot. That is with the United States Supreme Court, or SCOTUS, as I may refer to it throughout the semester. In order for your case to be heard by the SCOTUS, you have to file a writ of certiorari. This is a request for the justices to review your case. Before they even hear the case, 4 justices will review it, and if they decide they are willing to take it on, then they will hear it. This is called the Rule of 4. If you cannot convince 4 justices to hear the case, then you are not given certiorari. Your case is finished. If your case is heard, then the SCOTUS will either overturn or affirm all of the decisions made by the lower courts. If you do not get a ruling that goes in your favor, then you are pretty much out of options. The SCOTUS is called the Court of Last Resort, and there is no changing things once they make their ruling. The ruling that is made will be referred to in future cases and serves as precedent for future rulings. We call this stare decisis. State court systems are pretty similar to the federal system. There's no overlap between the two except for cases that end up going to the SCOTUS. The cases at the state level start with the courts of original jurisdiction. That's where all original trials, or trial de novo, begin. The defendant is either found guilty or not guilty. If the defendant is found guilty, then they can appeal. If the defendant is found not guilty, then the state does not have the same ability to appeal that the defendant does. Once the defendant decides to appeal, they can only appeal on a procedural issue. The intermediate appellate courts do not consider any new information, but instead, they review the case to make sure that all of the evidence was properly entered during the discovery, that the defendant has proper counsel, or if the defendant was properly Mirandized during their arrest. If the defendant does not win this appeal, he has one more shot at the state level. The state Supreme Court is also known as the Court of Last Resort for all state cases. Both the state and the defendant can appeal rulings from the Intermediate Court of Appeals at this Supreme Court level. But once the court makes its ruling, then again, there's not really anything else to be done. There is one minor exception in which the defendant can appeal state Supreme Court rulings to the United States Supreme Court if the cases are related to a constitutionality issue. Otherwise, the defendant is out of appeals. In this lecture, we have explored the fundamentals of criminal law. We examined the differences between civil and criminal law. From there, we discussed the benefits and the problems that are embedded in common law and how that affects the future of the legal system. Finally, we addressed federal and state legal structure and the court structure at both levels. In the next chapter, we're going to build on these fundamentals even more as we examine constitutional limitations as handed down by the federal government.